concerned, I've got nothing else unless the court has one for me.
No, thank you very much.
My lady, my lords, I'll deal with the European Convention on Human Rights grounds first, then the EU law points, and then just a couple of very small sweeping up points. On the Convention, the legal basis of the Convention case is a challenge to the statutory regime. It's a challenge to the Investigatory Powers Act itself. And the basis of the challenge is that parts of the Act are not in accordance with the law. And that has the three classic elements that are set out in the European Court of Human Rights' case law. The first requirement is that domestic law has to be met. That's obviously not an issue here because the Investigatory Powers Act is the law. Secondly, the regime has to be accessible and sufficiently foreseeable to enable the public and also those operating the powers in the real world to know what the powers, the rules and the safeguards in fact are. And then thirdly, there have to be sufficient safeguards to protect against the risk of arbitrary conduct. And the way that's dealt with in the surveillance case law in Strasbourg is the Strasbourg court does that by imposing a set of minimum safeguards. Now this appeal is of course mostly about the third category. There are some perhaps more minor points about the second category where we say the rules have not been sufficiently made accessible to the public. But what this appeal is not, is it's not a challenge to the proportionality of the powers in the Investigatory Powers Act. Proportionality arises as an issue if and only if the powers are in accordance with the law, and we say that's where they fall. And when considering the proportionality of primary legislation, testing the proportionality of primary legislation against the standards in the Convention, the courts, for entirely sound and proper constitutional reasons, take a very cautious approach. And so my learned friend Sir James showed you Lord Reid's judgment in the Northern Irish abortion zones case yesterday, where Lord Reid said exactly that. You were shown paragraph 13 of that judgment. But what Lord Reid was expressly considering there, what he said he was considering, was whether or not legislation was disproportionate, not whether it was in accordance with the law. Different principles apply to whether or not legislation is in accordance with the law. And that is a point that's been repeatedly made in the Strasbourg case law and the domestic case law, perhaps most clearly by Lord Reid himself. And with apologies for yet more authority, could I hand up two further decisions. First of all, a decision of Lord Reid in Reid T, and secondly, a copy of the EncroChat decision that my learned friend Sir James referred to yesterday. Thank you.
The decision of the IPT?
Yes, the decision of the IPT. I've also handed up a short procedural chronology of some of the history of the case, and I'll use that in a moment if I may to briefly deal with the submission that some of the arguments put forward on this appeal were not properly advertised or set out in advance or run before the Divisional Court. I'll just use that as an aid to argument and to give some of the rest.
Is this to replace the chronology we got 3 days ago?
No, it's not an agreed chronology. It's been prepared by us, but it solely deals with the procedural history of the case, and so it gives reference to many of the pleadings and documents and where they're to be found. So I'm afraid it supplements the agreed chronology. If I could look at T first in the Supreme Court. T was a case about the criminal records check scheme, and under the scheme as it then was, the spent convictions of applicants were routinely disclosed, and the Supreme Court held that such arrangements were not in accordance with the law because they lacked some minimum safeguards that the court said were required by the Strasbourg case law. If I could pick up the judgment at paragraph 88, which is on page 87 of the report. Lord Reid starts off at 88 by explaining some of the history of the Convention case law and points out the constitutional history of the United Kingdom, It's never had a secret police or an internal intelligence agency, compared with some in other countries in Europe. And then over the page, that there has been growing concern about state surveillance, and that is reflected by the jurisprudence of the European Court of Human Rights. And then at the end of paragraph 88, he contrasts that with the protection offered by the common law in this country, that by comparison has been of a limited nature. And he uses Malone back in the 1970s as a contrast, where very little protection for privacy was provided by the common law, and more substantial protection was provided by the Convention. Then paragraph 89, he points out the United Kingdom has often lost cases in Strasbourg involving surveillance on the basis that there were not adequate safeguards, that the regime was not in accordance with the law. And paragraph 89 sets out some of the greatest hits. And then at paragraph 94, he explains the approach which the Strasbourg Court has always taken to the question of in accordance with the law. And he points out in the third line of paragraph 94 that the consideration starts with the question of whether the interference is in accordance with the law, and it often ends there. That is the basis on which these cases are often decided. He then goes through the Strasbourg case law, which I don't need to trouble the court with. But turning on to paragraph 108 on page 92, he explains what in accordance with the law means, that it includes protection against arbitrariness, cites a series of cases from Strasbourg. All of those are telephone tapping or security service database claims. And he emphasises that the Strasbourg case law requires what he calls, at the top of page 93, clear, detailed rules governing the scope and application of measures, as well as minimum safeguards concerning various things. Then sets out the Secretary of State's challenge to those principles and that approach. And then at paragraph 113, the Secretary of State's challenge to that analysis is rejected in quite firm terms. And what Lord Reid again emphasises is that the Strasbourg case law requires, as he puts it, law which is between E and F, clear, detailed rules on the subject, especially as the technology available for use is continually becoming more sophisticated. There's no suggestion in this judgment, because of course it's not the position, that clear and precise rules can be substituted for by simply giving the Secretary of State or some other decision maker a general discretion and relying or trusting them to read all of the Strasbourg case law and apply appropriate safeguards in their individual decision making. That has in fact always been the basis on which the United Kingdom has lost cases. So in Liberty in the United Kingdom, there was a discretion to make interception warrants, including bulk interception warrants. And it was the absence of safeguards on the face of the legislation and the code of practice that led to a finding of unlawfulness. And Lord Reid gives several other examples. Then at paragraph 114, he explains the principal difference between in accordance with the law and proportionality. And then the critical conclusion is 115 from the second paragraph, second sentence. Whether a system provides adequate safeguards against arbitrary treatment and is therefore in accordance with the law is not a question of proportionality and is therefore not a matter in relation to which the court allows national authorities a margin of appreciation. That's why the Strasbourg Court sets out minimum standards. Now, with respect, I think it's fair to say that some of my learned friends' submissions elided the two different issues of in accordance with the law and proportionality. And they are different. My learned friend also referred the court to Roberts on the question of the legal principles to be adopted, another Supreme Court case. Perhaps it wasn't the most difficult case the Supreme Court has ever heard. The facts involved a fare dodger on a bus who was caught by a ticket inspector. She was asked to get off the bus. She gave a false name and address that didn't check out. She was handed over to a police officer. The police officer asked to look in her bag, and then she ran off. And the police officer, with the help of several of her colleagues, stopped and searched her under statutory powers. Not a particularly difficult case on the facts. And none of the principles from the database of state surveillance cases were considered in that case. And that's because the search that was carried out was overt. Mrs. Roberts knew that she was being searched, and she was told why she was being searched at the time. And so that case does not provide any assistance on any question of principle before the court. So that brings me on to the convention grounds. First of all, journalism. One of the important issues that the court is being asked to decide is why the journalistic protections are going to be, we're told, applied by concession to bulk interception, but are not going to be applied across the piece of the bulk powers. The argument that's put forward by the respondents is they want to have the ability to test this point in Strasbourg, and therefore they invite this court to apply the other principle and not to determine it.
Well, that's one aspect of it.
It's one
I
aspect,
think
there are others too.
The other aspect is that you can't read across. I mean, that's a principal ground, isn't it?
Well, they say you can't read across because it said there is a difference. And I'm going to address both that and also the suggestion that this argument was not properly presented to the Divisional Court or considered by the Divisional Court. So those are the different elements of the argument which are put forward. That the court shouldn't decide it because of the other principle. That in any event there is a principal difference, and that for some procedural reason it would be unfair to the respondents to decide the point. We say all of those are bad points. The argument that's put forward, as my lady rightly puts to me, is that there is a difference between, for example, bulk interception and bulk equipment interference. And what my learned friend said yesterday was that equipment interference was a backward-facing power. And he went as far as to submit that the equipment interference powers, as he put it, are going for a snapshot, not a live feed. Now, as a matter of law, that submission, we say, is thoroughly bad, because interception, under Section 4, may cover stored material. So both powers may be backward-facing.
But is that enough? Because both may be backward-facing, but one is only backward-facing. It may be that the interception ones are looking at transmission, but they may, on one analysis, cover some storage as well. But isn't that really just to ignore something, the fact that the one can't be in transmission?
If I can ask that, then perhaps the rhetorical question, which I'll seek to answer, why would it make a difference that it's backward-facing when it comes to analysing or identifying the source of a journalist?
Well, that's the question, yes.
But we say that the distinction between a so-called forward-facing and backward-facing power is one that is irrelevant in the context of finding a journalist source, and in practical terms is a modest difference indeed, because interception can be used for the same purpose. So that's looking at it from one side of the mirror. On the other side of the mirror, material is stored on a computer system immediately. As soon as it arrives on a telephone, it becomes stored and available for equipment interference. And it may well be stored in transit as well. And so therefore the requirement of storage does not provide any material distinction, because data is held straight away and is available for equipment interference straight away. There is only a tiny moment of time from the completion of the transmission to the moment of storage, at which point equipment interference becomes fully available. For all practical purposes, a live feed can be obtained. And that is why Mr. Dix, in his statement that I showed the court on Wednesday, accepted that bulk equipment interference was a fast-growing alternative to bulk interception. So one asks why not provide the same safeguard for journalist sources and confidential journalistic material. And all of that, we say, is confirmed by the recent decision of the Investigatory Powers Tribunal in the EncroChat case. I've handed that up. I don't rely on that case for the interesting and, even I would say, very complicated analysis of some enormously difficult legal issues. But it's relevant because this is the first case of which the appellants are aware in which the contents of an equipment interference warrant have ever been publicly disclosed. And so the nature of such warrants in practice can now be seen in open court. And that's dealt with by the tribunal at paragraph 77 of its judgment, where they quote from the warrant. As I'm sure the court will know, the EncroChat operation was an operation by the French authorities to hack into all of the EncroChat phones, which were specially modified phones designed to heavily encrypt all of the data going in and out of them. And they were used by the criminal fraternity for essentially and solely criminal purposes. So paragraph 77 sets out what the French authorities were doing, and there were two stages. Stage one was what my learned friend Sir James calls backward-looking, historical data collection. So it collects the data stored on the device and transmits it to the French authorities. It includes all data on the devices and is expected to include identifiers. There's a mobile phone codes and usernames, passwords, chat messages, geolocation data, images and notes. So, first of all, this is a technique which, if anything, is more intrusive, not less intrusive, than interception, because it obtains material that the owner of the phone has been careful not to transmit over a public communications network. So a journalist might make a note on their phone of the identity of a source. That would not be obtained by interception, but it could be obtained by equipment interference. So this is a technique, it is apparent, is more intrusive and is more requiring of safeguards than interception. Then we're told that the implant will remain installed on the device to enable stage 2. And stage 2 is forward-facing collection. So communications such as chat messages stored on the devices will be collected throughout the duration that the tactic is deployed. So live and ongoing collection, we're told, on an ongoing basis, and then at the end, as a result, this is considered as being conduct that's capable of being authorised under a thematic equipment interference authority. And that's because the messages are only collected once they're stored. But storage happens immediately, and then the transmission to the French authority happens immediately. The phones are modified to defeat the encryption and send everything that comes in on them straight back out to the French authorities in a form that they can read. So live transmission, which is for all practical purposes, and in terms of the interference with privacy, identical to intercept. Now, in these circumstances, and given that the warrants are in fact being used for these purposes, what is the proper basis, we ask, for not applying the same safeguards for journalist material when the degree of interference is at least the same, and if interference is conducted under stage 1 type warrant, as we see here, substantially greater than could ever occur under intercept. The respondents rightly point out that the Uller test can be quite exacting, and it requires a degree of confidence in the court as to what the Strasbourg court will decide. We say that any such requirement is amply met. There can be no sensible doubt in our submission as to how this would be resolved by the Strasbourg. Just before leaving that case, and on the extent of the interferences that can occur, could I also ask the court to have a look at page 38, paragraph 137. There's a quotation in paragraph 137, which is also a quotation from the warrant instrument, which sets out a further capability that the warrant authorised. And that is that the handset will routinely scan for Wi-Fi access points in the vicinity of the device, will instruct the handset to provide a list of those access points, such as a router, in the vicinity of the device, and will result in the joint investigation team receiving the as a technical address, which is a unique number allocated to each Wi-Fi access point, and the identity, which is the human readable name given to that access point. Now, the effect of that is that the phone would report back to the French authorities the unique identity of every Wi-Fi access point, such as the one sitting on the wall there, to the French authorities. So it provides continuous feed of location data as well. So again, capabilities which, if you did it by means of a communications data authorization, everybody in this court accepts would have to be done using prior independent authorization. But it said that somehow this capability was different. We say it's not. It was also said yesterday that this issue had only arisen on appeal, and therefore in some way the respondents have been deprived of the opportunity of putting in evidence that they would have liked to put in that would show in more detail the differences between these techniques. We say by reference to the procedural chronology, that is entirely incorrect.
I think the underlying point was we didn't have a benefit of the Divisional Court's decision or reasoning in relation to this particular issue, because the premise of the argument is what's required under Big Brother Watch, and that hadn't yet been decided.
Yes.
That's really the point.
Can I show my lady what happened after Big Brother Watch? Because the Divisional Court gave the respondents an opportunity to serve further evidence. And they did serve further evidence, and indeed it's the evidence of Miss Montgomery Pott which my learned friend has relied on to say there are differences between techniques. And that evidence was in extremely brief terms. So,
and where was that adjudicated upon?
That was not adjudicated on before the Divisional Court. It's only been adjudicated on here, or will only be adjudicated on here. But the important point is that these are points that were raised and advanced by the appellant throughout this case. And at every opportunity.
I'm not clear. They gave evidence after permission to get. They'd given their judgment, obviously, before the Crown Chamber, but somehow after they'd given judgment, they gave permission for fresh evidence in this court.
Shall I show the court what happened? Yes.
Good idea. I don't quite know.
Yes.
I don't know when they're given.
They didn't give permission for fresh evidence in this court. They gave permission for evidence because there was a further hearing in 2022, and the respondents wished to put in updating evidence, and they did.
For what purpose?
What was that about?
Yes, the purpose for which they did do it was to explain that following Big Brother Watch, it was now being conceded that the convention had been breached in relation to bulk interception and journalist material, but that concession was not being extended more widely. And then there was a very brief explanation as to why. I assume that evidence was put in, one, because it was recognised that all of these issues would be live in this court, and we didn't object to the evidence. And secondly, because the issues were live as a matter of EU law, which is the third EU law ground. But I think that's why they put in the evidence. We don't know, and we don't object to it. But we suspect that was the reason.
It's not quite the same as having a fully blown hearing on this issue in front of the Divisional Court. Is it?
No, that's right. I'm not suggesting that this point about, for example, whether there are additional facts which distinguish bulk equipment interference from bulk interception was a point that the respondents argued before the Divisional Court. They did not argue that before the Divisional Court. What they did instead is they adopted a much more absolutist position. They said under none of the powers which are bulk should there be these additional safeguards. Now, they have, having lost that point in Strasbourg, they've tried a more refined argument, and they put in little evidence in support of that more refined argument. But the idea that because they didn't...
I just don't understand when they'd put in the evidence, because they'd lost in the Divisional Court before Big Brother in the Grand Chamber.
Right.
So It just came about by chance afterwards. It's just
Can I show the court what happened? Because I'm seeking to explain solely to make the point that it would be unfair to the appellants, and this is why I make the point, it's unfair to the appellants for this issue not to be determined. And that is because this is an issue which was squarely raised by the appellants 5 years ago and was fully pleaded on both sides 5 years ago. And so for the respondent to say, as was briefly said yesterday, that in some way this court should not consider whether there is a breach of the convention, we say would be wrong in principle. And that's why I mentioned the history. Can I just show the court the relevant parts of it as to why we say that? We pleaded this point and these issues in 2017. I won't take the court to it, but page 644 of the core bundle, paragraph 64, is our original pleading.
Sorry, which page did you say?
Page 644,
Yeah.
paragraph 64, is the claimant, then was the original pleading. The claimant pleaded a requirement for prior independent review, cited all of the cases, Sonoma and Telegraph, those are the cases at the time, and then those principles were applied in the pleading expressly to each of the bulk powers. So
you keep saying bulk powers. It's better to say, because things that you call bulk powers, I may not agree with bulk powers.
Indeed.
So do you mean parts 6 and 7, or do you mean parts 4, 3, 4, 5, 6 and 7?
All of parts 5 and 6 and 7. And to give my lord the references for that, it's paragraph 100, page 692, which deals with bulk interception. Paragraph 707 for bulk acquisition, and paragraph 720 for bulk equipment interference. So there was an express pleading that there was a requirement of prior independent authorisation before accessing, for the purposes of obtaining a journalist source or confidential journalist material. The respondents knew this point was well in issue, and they pleaded to it as well. The reference to their pleading is page 593, paragraph 117. And all they said is essentially that the Divisional Court shouldn't decide the issue, they should await a decision from Strasbourg, and that was said to apply across the piece of all the powers. They also served at the same time the evidence of Mr. Dix, and Mr. Dix, of course, described equipment interference as a developing alternative to interception. So far from saying the powers were fundamentally different, he emphasised their similarity. And there was no argument put forward that a different approach should be adopted as between the bulk powers. We then served evidence in reply, and the evidence in reply included a witness statement of Mr. Cobain, who's a journalist. That's in the supplemental bundle at tab 4. Again, I'm not going to take the court through it, but at paragraph 64 to 66 of his witness statement, he deals with the absence of prior independent authorisation in relation to those, what I'm calling bulk powers. He explains that for all of those powers, he considers that the protections are equally required. So there can be no doubt about the case that was being run. And in fact, although this court haven't been given it, there was a second witness statement of Mr. Dix, and Mr. Dix served a very lengthy response to Mr. Cobain's statement, dealing with many points, but he did not suggest that there was any reason to treat the different bulk powers differently. The point was then argued below before the Divisional Court by my learned friend Mr. Bunting. Again, I'll just give you the references, but his skeleton argument dealt with each of the bulk powers separately and explained in considerable detail in his skeleton why independent authorisation was needed for each of the bulk powers. That's
Yes, well, what's missing is as it were, the important intervening event of Big Brother Watch, because I'm just looking back at your skeleton argument on these issues, which pins its colours firmly to the mast of Big Brother Watch. And we understand the arguments you make in relation to that. So really that the issue is, as I think was said to you on day one of this appeal, whether we are dealing with it as effectively as a first instance court or as an appellate court, because we have nowhere any reasoning by the Divisional Court on the implications of Big Brother Watch, whether they go further, as you submit, to the different parts of the Act than the one that, or the power, I should say, or other than the one that was under consideration in the in 8.4 of REPA.
Yes. The position this court is in the position that there is a fully pleaded and argued case that the journalistic protections apply across the piece of the bulk powers. And that's a submission that was rejected in its entirety, with reasons, by the Divisional Court. The Divisional Court said, you don't get the journalistic protection the claimant wants for bulk interception, now conceded that was incorrect as a result of Big Brother Watch, there's a concession there. And the Divisional Court said, and that applies to all the other bulk powers as well, and understandably, given the Divisional Court's conclusions about bulk interception. So the Divisional Court said, across the piece, no protection. There's been a supervening event, which is the judgment in Big Brother Watch, but nonetheless, the case that was advanced below, and as I'll now give you the references, our grounds of appeal and the evidence, specifically maintain the case that has always been.
We understand that. Thank you.
I'm sorry I'm belabouring it. It's
Yes.
just that there was quite a significant suggestion yesterday that this court, it would be inappropriate for this court to deal with it. And the prospect for the claimant of having to start a new claim to deal with that issue, an issue which the claimant has pleaded and advanced for over 5 years, would we submit be a wrong one. The references to Montgomery Pot, where you get such as it is, the point that the powers are different, is page 172 of the supplemental bundle. There's a couple of lines of that witness statement that suggest the equipment interference powers are different. I've addressed that. And she also explains in her witness statement the concession, which we all know what it is, in relation to bulk intercept. Now, the only way of understanding the Montgomery Pot witness statement, which refers to both the concession and also identifying for the first time the difference between the powers, is that that's the point that the respondents were going to rely on in this court.
I'm sorry, Mr. Jaffe, to slow you down. Montgomery Potts, there's a second witness statement at page 154 of the supplementary bundle.
Yes.
By the time you get to 172, the supplementary bundle, certainly the bundle I've got, I'm thinking that's something quite different.
Which page is it?
And I was foxed by some of your earlier references on this point as well.
Well, I'm sorry if I've given you a massive series of bad references. Can I just make this one good? First of all, Montgomery Pot, the reference which I gave the court was wrong. It should be the witness statement of Miss Montgomery Pot, which starts at page 220.
Okay.
The concession.
That's the first one.
That's the first one.
That's
The first one comes in at tab 17. The second is at tab 7, which starts at page 154.
Yes, I'm afraid I've given the wrong reference.
Neither of them have a page 172 in them.
So which one would you like us to look at?
Can I give you the corrected reference? I'm sorry, I've given you.
All right.
So Montgomery Pot, page 220.
120. So it's the first witness statement.
Which is the first witness statement of Montgomery Pot. This witness statement comes after the judgment of the Grand Chamber in Big Brother Watch. And the concession is set out at page 230, paragraph 45C.
Which paragraph did you say?
45 letter C,
Yeah.
the heading thirdly, and Ms Montgomery Pott refers to the Grand Chamber's judgment and explains that legislative changes will be worked on.
So what am I getting out of this?
So after the Grand Chamber, this is the first time the concession is made, and then
After the Grand Chamber, after the decision of the Divisional Court as well.
that's right.
Yes.
The concession is made, and then turning over to page 232, at paragraph 52. There is the only evidence which was either before the Divisional Court or this court, alleging differences between the technique of bulk interception and bulk equipment interference. And Ms Montgomery Pott, in the sixth line, makes the point which you've heard in submissions about a distinction between backward-looking and forward-looking powers.
And that this witness statement came before the third hearing of the Divisional Court.
That's correct.
I mean, the court never considered it, the Divisional Court, did they? Because they finished by then.
No, the Divisional Court hadn't considered the evidence because they decided. The European
Which they
Convention on
did
Human
before
Rights.
the 1st of March 2022.
Yes. And
Just like it's an update.
Yes.
There we are.
It's an update because this case was going to the Court of Appeal, and Ms Montgomery Pott thought it appropriate that first of all this court was told there was a concession on part of the case, but as can be seen from paragraph 52, we have the germ of the argument that's been advanced before this court that the concession would not go wider.
I don't want to take you back over the references, but I was trying to follow the references you gave to the pleading points.
Yes.
Could someone send an email later with just those references?
I will check that those references
because
were correct.
I was even more at sea than.
Yes, I'm told I've mixed up the paragraph and the page numbers. I think that's what I've got wrong.
Thank you.
I apologise for that. I was trying to save time, which in that way always takes
Thank
time.
you.
But the position, which I'm satisfied is correct, having checked the references myself, is that these points were pleaded in detail.
Okay.
There is no evidence that was put before either the Divisional Court or this court that it would be impractical to impose these safeguards. The furthest that the respondents have been prepared to go in their evidence is paragraph 52, which contains in essence a submission, which I say is wrong in law and wrong in fact for the reasons I've sought to identify. And in addition, there is a submission in my learned friend skeleton that there might be sensitive closed evidence that could be deployed to support the point made in paragraph 52 of Ms Montgomery Scott's first witness statement. Well, the procedural position in this case is that the Divisional Court made a Section 6 closed material procedure declaration under the Justice and Security Act. So there was an application for a declaration which was never formally determined, but nonetheless that gives the power to serve closed material. And there's been no attempt at any stage to rely on any closed material by the respondents in these proceedings. Parliament has introduced a procedure for that. The procedure was applied for in this case, and it has not in fact been used. And then finally, Mr. Bunting said in his skeleton argument before the Court of Appeal that if there was any further evidence that it was intended to be relied upon in support of this argument, there was a distinction between the powers, then it would need to be produced quickly. That's paragraph 36 of Mr. Bunting's skeleton. We suggest that where we are, and it is unsatisfactory, that the Big Brother Watch Grand Chamber decision has come down in between the Divisional Court's judgment and this court hearing the case. But ultimately, the procedural position this court is in is that there is an argument that was squarely before the court below, which the court, we say, rejected wrongly, and the court can be more confident of that than it might have been before because of Big Brother Watch. Just that the law has shifted in the appellant's favour. And all of these arguments are ultimately an attempt to really put off the evil day when all the bulk techniques, all of equal seriousness in terms of their ability to interfere with journalistic rights, are subject to the same set of minimum safeguards. Ultimately, the appellant's position is we can all have a nice day trip to Strasbourg with a good lunch afterwards to resolve the point. But this is not a case in which there is any serious doubt as to what the outcome will be.
Well, I'm going to go back and say again what I said before, which is that we noted the concession made that the agreement that the case should proceed before the Divisional Court, and it's unsatisfactory that we're placed in this position, but there we are.
The final point on journalism is about confidential journalistic material and sources, and that was the point that my learned friend Sir James addressed at the end of his submissions this morning. With apologies for asking you to go back to section 264, hopefully a final time. Page 2925 of the bundle. The argument put forward by the respondents was that section 264 subsection 5, that's the carve out for criminal purposes, applies only to the concept of confidential journalistic material, and it doesn't apply to what's said to be the different concept of a source of journalistic information as defined in section 263. That's the argument. The difficulty with that argument, as the appellant sees it, is that section 264 subsection 5 opens with the words, for the purposes of this section. And so my learned friend Sir James places reliance on that and says, well, that's just the provision for this section. It just deals with confidential journalistic material, and that gives you comfort that the provisions for sources are rather different. The problem with that is section 264 subsection 1, which says that the definitions in this section have effect for the purposes of this Act. So they're given broader effect. And we're told in subsection 5 that material is not to be regarded as created or acquired for the purposes of journalism if it's created or acquired with the intention of furthering a criminal purpose. So what is being defined are the purposes of journalism. And then we look at the...
So you know what's being defined is journalistic material, isn't it?
And isn't it focusing on the journalist?
Well, it may or may not be, but...
What the centre of it is the creation or acquisition by the journalist, I would think.
What is being defined in 5A is that material is not to be regarded as created or acquired for the purposes of journalism. So it's telling us what the purposes of journalism in fact are. And it seems to be defining those.
Well, no, you've got to read two. Journalistic material means material created or acquired for the purposes of journalism. So then you go down to 5A, and material is not to be regarded as required for those purposes if it's created or acquired with the intention of furthering a criminal purpose. It's tied to material, not purpose in some kind of abstract way.
Well, the potential difficulties, I do see that point, and I believe, and the submission that we make is that these provisions are ambiguous.
So if you get a judgment saying it is what Mr. James says, A, it won't be ambiguous, and B, you'll be delighted.
That's absolutely right on both points. I'm simply identifying what the potential difficulty is.
Yeah.
And
Do you say anything about journalistic information? Whether that's
could I just compare the words that used in section 263, subsection 1, the source of journalistic information? Because the source definition is an individual who provides material intending the recipient to use it for the purposes of journalism. And if that definition of the purposes of journalism is copied across from 264 subsection 5, then the material will not be being used for the purposes of journalism because of the criminal purpose. That's the ambiguity. And as I've said, we would entirely agree with a construction of this legislation that provides proper protection for journalistic sources.
So as long as you remember that 5A mustn't be read in semi-isolation, and it's not defining purpose of journalism in some kind of abstract university seminar sense, but is a qualification on material, and you remember that, then all is well in the world.
Not quite.
Oh.
Let's assume that that is correct, where we left. Where we're left is that as of today, section 154, bulk interception, does not cover journalistic sources at all. And in relation to bulk acquisition and bulk equipment interference, these are points I've already developed earlier, there is no relevant protection for journalistic sources at all. And
Let's say that again. I missed the first part, I didn't quite catch it.
So, first of all, section 154 in its current form for bulk interception does not and has never provided any protection for journalistic sources. It only provides protection for confidential journalistic material, as defined, which of course is cut down on any view by subsection 5 of section 264, the criminal purpose. So as of today, even if my learned friend Sir James is right about the proper interpretation of the definitions, there's still no protection for journalistic sources. That's why they accept a remedial order as necessary. Even if they're right about that, because section 154 only covers confidential journalistic material at present. I don't think that's in dispute.
Right, but they're going to change it, aren't they? Or are they, this is part of the session.
They are hopefully going to change it.
Right.
Then, following that, there are also, at present, no protections either for confidential journalistic material or journalistic sources for bulk acquisition or bulk equipment interference. And that's the read-across point I've already developed. So even if Sir James is right about that, about the correct interpretation of the definitions, there remains a problem. So that's the current status of the position in relation to journalism. Round 2 raises some linked issues in relation to the application of Big Brother Watch to all the bulk powers. The point that is seriously an issue between the parties on ground 2 is first of all the issue of certification and the RIPA, and whether it's the same as operational purposes. The difficulty, and I can encapsulate this in essentially a sentence, is that the nature of certification was considered in the Big Brother Watch judgment, and the UK's position was found to be wanting. The only answer which the respondents have to that is that they say there was nothing in the RIPA scheme requiring more detailed particulars than simply the words national security, serious crime or economic well-being. That's a submission which is simply incorrect on the facts, because the Code of Practice imposed exactly such a requirement. And that's a submission which I made on Wednesday, and it's Big Brother Watch on page 2233, citing the Code of Practice that imposes precisely such a requirement for specificity. The second issue on ground 2 is secondary data. And I think it is, having heard my learned friend's submissions, accepted that the concept of secondary data is much wider than the previous concept of communications data in RIPA. there was no attempt to respond to any of the examples we've given. So the concept is extremely broad, and it means that there is less protection for secondary data than there would have been for the equivalent data under RIPA. The search is then for a justification for that change in position. And our short submission is that one hasn't been advanced.
Well, is that the question? I mean, the question is whether or not the safeguards that are there are adequate.
Yes, and what the Grand Chamber said in Big Brother Watch is that it should not be assumed that things which were not content were inherently less intrusive, and that it would depend on the circumstances and any justification for the treating of non-content different from content. Here, what has happened in the legislation is that there's been enormous expansion of a category which receives less protection, which on an ordinary analysis would be viewed as containing the substance, or dare I say it, the content of the communication. And therefore that reduction in safeguards ought to be accompanied by some form of reasonable justification.
Is that a legal requirement that if you change something, you must justify it? Or is the law simply that you must justify that which exists now as being adequate?
Well, it may boil down to the same thing, because the appellant asked the question of what the reason or basis for the change is. Why is it necessary and proportionate to provide less protection?
Well, that's the question I'm asking you, is what is the legal obligation? Is it to justify making changes, or is it to justify the level of safeguards?
It is overall to justify the level of safeguards, but where the safeguards are being reduced from those in a scheme which has itself been found to not comply with the convention, that is likely to require some evidence or explanation. And what is notable and striking is that it just hasn't been one, we say. There hasn't been any attempt to make a submission or provide an explanation as to why, for example, someone's activity on a dating site, or we say what they type into Google, ought not receive, for example, the British Island safeguard, and why that safeguard has been removed, because that comprises the substance of the communication.
But it's the same point. I mean, there may be no justification for the change, but we've still got to ask whether what say is enough that we've got it.
Yes. We say nothing has been advanced, and the burden of justification is ultimately on the respondent and not the appellant. Then the final point on ground 2 is internal authorisation of strong selectors. That's been conceded for bulk interception only. But again, and this is a point that I've already developed, there's no explanation that has been offered as to why that safeguard is not being applied to the other bulk powers. The only point that was made in oral argument was my learned friend Sir James cited the Equipment Interference Code of Practice. And you'll recall that this morning he showed you a box containing a hypothetical example of use of that power. And that power might be used to interfere with large quantities of computer software in order to check many users of that software in order to see what they were doing. And he said it might be impracticable to get authorization for such an operation. The reference for that is page 3762 of the authorities. The problem with that is that this requirement in Big Brother Watch only applies to strong selectors, and that operation was not one involving strong selectors. It was, by definition, not a strong selector because there was no attempt to target particular identified individuals. It was instead attempting to target all users of a particular piece of computer software to find which ones were potentially of interest. And the European Court of Human Rights and Big Brother Watch made very clear that there was no requirement for prior internal authorization of such selectors. It was only strong selectors. So with respect, we don't consider that that submission assists the respondent. Sharing ground 3 short point is that the point which the respondent did not answer, and we say were unable to answer, is that the RIPA Code of Practice was the basis on which the sharing arrangements were found to be lawful in Divisional Watch. And it was because that Code of Practice contained a series of express mandatory safeguards in relation to sharing. Those safeguards have now been deleted from the current Code of Practice, and the content of the legislation, the content of the Investigatory Powers Act, is materially identical on sharing to RIPA. And so the basis on which the Grand Chamber in Big Brother Watch found the RIPA scheme to be lawful in relation to sharing has now gone. And those provisions can only have been deliberately deleted in the most recent Code of Practice, because the respondents are well aware of what the Grand Chamber said about sharing in Big Brother Watch. So a choice has been made that even though those particular provisions in the Code of Practice were the only basis on which the court was able to find the conduct was lawful, a choice has been made to delete them and therefore reduce the protection. And so therefore we say in those circumstances the safeguards which are mandatory, which are required in relation to sharing, are not present in the legislation or the Code of Practice. And there is a breach of the in accordance with the law requirement. On legal professional privilege, just a single point about RE in the UK, which was relied upon by the respondents in support of their case. What happened in RE in the UK was that a lawyer-client conversation in the police station was bugged. RE in the UK was a case which, under domestic law, under UK law at the time, that bugging required and received prior independent judicial authorisation. And that was because under RIPA at the time, surveillance of a conversation between lawyer and client was categorised as intrusive surveillance, and therefore, when it was conducted by the police, as it was here in RE, required the prior approval of a surveillance commissioner, who had to be a judge of at least circuit judge rank or above. That is all explained in paragraph 52 of the judgment on page 1672.
1676.
1672, my lord.
Thank you.
In fact, on a proper analysis, RE supports the appellant's case because the court didn't have to consider the question of whether bugging a lawyer required independent authorisation under RIPA. The submission which we make is that when the interference is essentially identical, then the safeguards ought to be in practice identical. And those safeguards, we say, ought to include prior independent authorisation. So let's say, for example, that instead of using a power in the Police Act 1997, or RIPA, to conduct bugging of the lawyer and the client in the police station by installing a bug in the light fitting of the conference room, let's say there was equipment interference of the lawyer's phone to activate the microphone and transmit the conversation to the police or the intelligence services. Why should the safeguards be different? The interference is identical, and we say that is the operating principle. And that's the point which was made in RE itself at paragraph 130. If I may turn finally and rather more briefly to EU law. The first ground relates to general and indiscriminate obtaining of data. The effect of a scheme being general and indiscriminate is common ground. That is that if you have a general and indiscriminate scheme for national security purposes, you need the limited suite of safeguards set out in La Quadrature. And also that if your purpose is to carry out a serious criminal investigation, then a general and indiscriminate scheme cannot be used. There will of course be some criminal investigations that also raise questions of national security, in which case those techniques can of course be used. So one could think of examples involving a terrorism investigation raising a question of national security. But what the Court of Justice has consistently said in La Quadrature, SpaceNet and GD is that it is unhappy with the idea of information that has been obtained for a national security purpose being repurposed for a criminal investigation without prior independent authorisation. The Court of Justice is saying, yes, these exceptional powers to protect the national security of member states are appropriate and justified, but once you start then reusing the data and analysing the data for different purposes, namely criminal investigations, then we do require independent authorisation before the data is used. And that is the appellant's attempt to encapsulate the ratio of Opinion 115, of SpaceNet and of GD. That's what the court is saying there. That is the vice which the court is seeking to prevent. As to what general and indiscriminate means, what stops a regime being general and indiscriminate is targeting. But the nature of the regimes that are an issue in this case is they are intended to be untargeted in terms of the initial obtaining of information.
That's a meaningless submission. Targeted can cover everything from the most limited reduction of scope to what you have been making submissions about. So don't you need to rephrase that submission? Because they're both so elastic as to be unhelpful, well, to me at any rate.
Well, the Court of Justice has not set what the precise boundaries are, and so inevitably it is going to be elastic. What the Court has said over the course of half a dozen, I think, Grand Chamber decisions is that this principle does exist, and we know that some cases fall on one or another side of the line. And the factors which the Divisional Court identified in 2018 as putting this case outside of being generally indiscriminate, we say no longer stand up to examination. For example, the idea that a discretionary basis makes a difference. We say that ultimately all a court can do is it can look practically at what the nature of the power is and how it's intended to be exercised. And then the logical nature of these powers is that they are intended to collect as comprehensive a data set as possible, for reasons I've already sought to identify. So instead of, for example, taking a hypothetical example of interception, it might be believed that a particular company's premises were being used to facilitate drug smuggling. And so a warrant is obtained for all telephones which are either connected to that company's telephone network and perhaps all mobile phones used within 100 metres of that company's offices or warehouse. That would be a very targeted warrant, and that would not be general and indiscriminate. And the reason for that is because there's an aim not to collect as much as possible and then sort it out later, but by a factor which is closely linked to and relevant to the topic of the investigation, choose what is collected. The difference with the bulk schemes, and we say it's a difference of kind, is that the aim is not to select in advance particular people or groups of people, or people in a particular area, or people using a particular type of computer software, but to select in advance and obtain as much as you can with the aim of sorting it out later and having on your database a comprehensive record to look back in time. And so a bulk acquisition scheme only really makes sense if you have everyone's communication state. And that's what we say the Court of Justice is ultimately getting at. And I understand it's elastic, and I also understand that it's unsatisfactory, and it perhaps also is not a common law technique of how safeguards are defined and applied. And all of those points have been made extremely vigorously on many occasions by those sitting to my right in the Court of Justice. And the Court of Justice has persisted in that case law. And it has, whenever those points have been made, said, no, this is an important distinction and it continues to exist. And in the Privacy International case, expanded and applied it to a discretionary scheme over the objections of the United Kingdom. So we say these are properly analysed as general and indiscriminate powers. That means that under ground 2 of the EU law points, that where the bulk provisions are being used for criminal law purposes, they do need to be subject, we say, to the same safeguards. And that's really the same point as the appellants have made previously about the difference between substance and form. That where the level of interference that's being conducted is the same, then the safeguards that ought to apply are the same. It shouldn't make a difference whether communications data is being accessed by a targeted request under Part 3, which would require prior independent authorisation, or whether you're typing the same mobile phone number into your bulk acquisition database and obtaining exactly the same data. When the interference is the same, why should the safeguard be different? That's the question which the appellants ask. The final EU point is the EU Charter issue. The appellants understand from my learned friend Sir James's submissions that it is conceded that the Divisional Court took the wrong approach in law. It's conceded that at least where the government makes a concession, the court can and should find a breach of the retained EU law, and in principle may wish to provide a remedy. Now, my learned friend then spoke of constitutional heresies. A decent candidate might be that the executive gets to decide, by means of whether it makes a concession or not, whether the court should consider questions of retained EU law. The argument that was put forward is that, well, yes, that there are retained EU law rights where the government concedes the position, but ultimately if the government disagrees about what the right approach is as a matter of law, then the court shouldn't carry out the task required of it by Parliament under retained EU law. And we submit that submission only needs to be stated to realise what's plainly wrong with it. Can't possibly be the correct approach. The final point that I wanted to make by way of sweeping up is just to answer my Lady the President's question about what independent means in relation to independent authorisation.
I think it's still within the Divisional Court's judgment, isn't it?
Yes, that was the reference that I was going to give. I'm very grateful. I'm sorry I've taken longer than I hoped.
Thank you very much. I think you've introduced some new authorities, and I think Sir James should be given an opportunity to reply on those if he wishes.
Not unless I can assist. And perhaps the only thing to say about the T authority is that the T authority was the one that I referred to in my responsive submissions, that then led to the culmination, which was P as cited in the Divisional Court's ECHR judgment. So that's the sequence. And so far as EncroChat is concerned, I'm afraid I haven't had the chance to read that terribly carefully as yet. But
you were in it, though.
I was in it. I didn't write the judgment, however. So I've nothing particular to say about that. I'm not sure it really advances the issue. So I've made my submissions about the need for caution. Perhaps the only thing that should be said about that is that I think my learned friend might at one point have been running into a confusion about the distinction between, which plainly exists between, on the one hand, inviting a court not to decide a point, and on the other hand, inviting a court to apply the substantive approach to ECHR issues, which is set out in AB. The substantive approach in AB, particularly paragraph 57, the fully confident approach, says that if you can't be fully confident, then you must adopt what they call a conservative approach to the resolution of the actual issue.
You're deciding it, but you win.
You
is what you're
decide it,
basically
but we
saying,
win.
yes.
And then they go off to Strasbourg, and Strasbourg tells us we should lose if that's the way it goes.
Can I just raise one thing? The appellant's procedural chronology, which we've had since lunchtime.
Yeah.
Does anybody want us to read it? And if so, to what end?
It was intended to provide the cross-references for my submissions, some of which may be wrong. What I suggest is that we'll provide a shorter email to the court just with the references I gave the court orally, and then hopefully I can avoid asking the court to read it. Would that be convenient?
Yes, thank you very much. Well, thank you very much to all those involved for written submissions and the oral submissions. We will obviously reserve our judgment or judgments in this case, and a draft will be circulated in the normal way for the correction of any errors or omissions, and there will be no need for anybody to attend at the handing down if we require any further assistance. And in this case we may, then we will ask for it. Thank you very much.